Hi, Tony DeWitt here, Missouri Appellate attorney and a guy who likes to make the law make sense on YouTube. Today we are going to talk a little bit more about the Stauch trial in Colorado and a little bit of the inside baseball on what's going on. So let's go down to the beach and talk about that. One of the things that you learn in law school is you learn the law of evidence. And the law of evidence is complicated and it changes pretty much every week if you really want to get down to it. There are new decisions issued, there are new evidentiary decisions issued, and the contours of the different rules are shaped a little differently pretty much every day. New decisions mean that you have to be up on the law when you do a case so that you can avoid getting reversed later on for an evidentiary error. But because the law is so complex, there are actual books out there that have lists of objections to make at trial. And at one point in time, I thought, boy, it would be really great to know and have a list for all of those objections because you'd be able to make the right objection at the right time and maybe keep evidence out. But one of the things they don't teach you in law school is psychology. And the other thing that they don't teach you in law school is how jurors think. Jurors tend to think pragmatically, and they tend to think in terms of cause and effect. So when someone objects to a particular question, the immediate assumption on the part of jurors is that, well, the right answer to that question is going to hurt that guy's case. And in many cases, that's correct. But there's also a valid legal reason for keeping many things out. Now, the reason I preface this about the Stauch trial is because they did not plead not guilty. Well, I shouldn't say that. They pleaded not guilty initially, and then they changed their plea to not guilty by reason of insanity. And the reason that's important is when you plead not guilty by reason of insanity, it means pretty much that you are not challenging that this woman did the crime. What you are trying to establish is that she lacked the capacity to understand the difference between right and wrong, good and evil, at the time that she committed the crime.
And here is the full test under Colorado law. The applicable test shall be a person who is so diseased or defective in mind at the time of the commission of the act as to be incapable of distinguishing right from wrong with respect to that act is not accountable, except that care should be taken not to confuse such mental disease or defect with moral obliquity, mental depravity, or passion growing out of anger, revenge, hatred, or other motives and kindred evil conditions. For when the act is induced by any of these causes, the person is accountable to the law. Or a person who suffered from a condition of mind caused by mental disease or defect that prevented the person from forming a culpable mental state that is an essential element of the crime charged, but care should be taken not to confuse such mental disease or defect with moral obliquity, mental depravity, or passion growing out of anger, revenge, hatred, or other motives, and kindred evil conditions, because when the act is induced by any of these causes, the person is accountable to the law.
Assuming that you have essentially stipulated that she indeed did do the crime, then many of the things that the prosecution is introducing, for example, the phone calls with her ex-husband, where she is going through all of the many different excuses for why she couldn't put Gannon on the phone, for what happened to him, who got him, who took him, where did he go? When he asked her directly, did you kill him? She said no. All of these things are important, right? If you are trying to demonstrate that she indeed killed the child. But if you are trying to demonstrate that she is insane, they're really not relevant. So one of the criticisms that I have seen leveled in comments of some of the other videos that I've seen is that the defense isn't doing enough, it's not making enough objections, and it's not pushing back on the state's case as hard as it could. And I think that's because the evidence here is pretty substantial and it would be very difficult. As you all probably recall from my earlier video, the evidence was so bad the guy feigned a walkout, right? It's just a lost cause. A lost cause is how he actually described it. And I think, again, that's unprofessional. I had a commenter on here who is an attorney who said the same thing, said that they were embarrassed for the prosecution, that they would pull that kind of stunt. A federal judge I know, who I at one time worked with as an attorney, described that kind of behavior as BFDQ, big fat drama queen. And I think that's accurate. But it's interesting to me to see how other people appreciate many of the same things that I did with respect to that opening statement. But I digress. Let's get back to what's going on here. Why is the defense not making all of these objections? For example, all of these things where eventually it leads up to the point where, they discover the body and that sort of thing. All of these things definitely point toward her guilt, but if her guilt is stipulated, they're irrelevant. So why doesn't the defense attorney object? He doesn't object because his goal is to prove that she is insane. And the more bad evidence that comes in about her and the many different stories that she's told and the many different excuses that she's offered, these all buttress the idea that she is nuttier than a payday candy bar. And the difference between being insane and just being evil is sometimes hair thin, but there is a difference. Now, if you ask me what I think, I don't think necessarily that she is insane. I think she is cold. I think she is calculating. I think she is exceptionally manipulative. And I think she's probably suffering from narcissistic personality disorder. All of that said, that does not establish the fact that she's insane or that she couldn't appreciate the wrongfulness of her conduct at the time she was committing that conduct. But that's really the issue for the defense. And so they're letting the prosecution get in all of this bad evidence. But here's the other thing the prosecution is doing. They're going very slowly. They are sort of plodding through this. They took more than a day to put the father on the stand and question him. And in the process, they played all these videotapes. And let me just tell you, if you want to listen to these audio tapes or if you want to watch the father's testimony, which basically means you can see the counsel table and you can't see the dad testifying. If you want to do that, that information is out there. If there has ever been a less visually interesting trial than this one, I don't know what it is. But in some respects, I'm thankful for that because I am certain that the graphic images that the jury is going to be shown are going to be so awful that you won't want to see them. And you may not be aware of this, but they brought in the suitcase where the body was found, and they had that in a plastic bag, obviously, but they brought that in and showed that to the jury. And I think that was a pretty powerful piece of evidence for the prosecution, but I also think it's a pretty powerful piece of evidence for the defense, because what normal, sane person would put a child into a suitcase like that? So while it may not appear to be working for the defense, I do think that it is working for the defense. But again, if you want to see all of that, the videos, the live streams are out there. You can certainly watch those portions of the testimony that you can see. But I would rather not bore you with the content that is readily available elsewhere. I would rather provide you with my analysis. So what does all of this evidence mean in the grand scheme of things for the defense. For the prosecution, it means she did the crime and she's guilty of killing this child. For the defense, it means, holy cow, this is really an awful case. How could a normal person do this? And of course, that's how they will phrase it. How can a normal person do this? But that's not really the question. The question is, did she appreciate the wrongfulness of the conduct at the time that the crime was being committed? And if you look at sort of the way that some of the things happened, for example, calling her school and telling them that she couldn't come in because her father on the East Coast had been killed in a traffic accident, or her stepfather, I can't remember which it was. That is the kind of manipulative and lying behavior that indicates both a knowledge of the presence of guilt, but it also indicates scheming and planning. Generally speaking, when people do things because they're insane, they have disordered thinking, not logical, ordered thinking. In other words, they do the crime and then, holy cow, I did the crime, and they flee. They don't think, okay, I did the crime. How am I going to hide it? I know. I'll go back and fix all of these things. And when you see what is going on here, you realize that, at least I've realized, that she is essentially going back and trying to cover her bases, which is something that I don't think, for the most part, an insane person would do. I think they would flee. And again, while there is sudden insanity, fugue states, that sort of thing, I don't think this really qualifies as a fugue state kind of thing. I think this was planned, premeditated, and heinous. The real task for the defense here is to characterize this as not being normal, and in so doing, convince that one juror that she is indeed that payday candy bar. That's a tough task for them. And I would point out that in the situations where they have cross-examined witnesses, the one really good thing that they have done is they have not hurt their case further. In other words, they ask questions about her mental state. They don't say, gee, tell me again about all of these wounds. And they don't do that because they don't want to further, they don't want to hurt their case. So the defense has limited their cross-examination into essentially looking at her mental state. Each one of these witnesses that are being put up by the prosecution, to the extent that they had direct interactions with Letitia Stauch, they are all being asked by the defense anyway. They're being asked by the defense whether there was any interactions that gave them a clue or that could later be spun into a clue about her mental health. And that's important because when they close this case and they argue this case, they're going to have a list of all of these witnesses who gave them some little nugget about her mental health status. And all of that will come back in front of the jury. And it's a really good thing that she is well represented in this regard. Although I think they blew the opening statement badly, I would say they have rehabilitated themselves very nicely on the way they have handled their cross-examination, in that they have not engaged in shooting themselves in the foot. This week's trial continues. Again, I think it is visually uninteresting. I'm not going to put up minutes and minutes of video footage that show absolutely nothing. At least with these other trials, they have been visually interesting. This one is not. And I understand that the media order in this case only allows for one camera, and apparently the courtroom is set up in such a way that they can't set the camera up so that the witness and the attorneys are both, there's only one camera. So for that reason, it is all you're getting is the view of the counsel table, and it's, like I said, not been a particularly compelling view. Well, that's what I have for you today. I wish I had some video to share for you, but again, it's just not that compelling and it's not that interesting. So I would rather talk to you about what is interesting, and hopefully you found that worthwhile. Thank you again for watching. If you have the opportunity today, please take a moment to do something nice for someone. Have a terrific day, and I will catch you down here at the beach next time.
If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.